So, welcome back to Afrolantican Jurisprudence, the place where we discuss law and economics from an Afrocentric perspective. This is episode 7, where we're going to talk. Actually, it's an extension of episode 6 because episode 6 we talked about asymmetrical market imperfections, or describing racism or any type of group subordination as asymmetrical market imperfections relating to race, gender, sexual orientation, etc. And then that would be more or less the hallmark of what I'm describing as Afrolantican jurisprudence, or basically the primary distinction between how I conceive of um, Afrolantican jurisprudence, or the structures and the constructs within the law to interpret and see outside of itself. Again, part of Afrolantican jurisprudence is also on a deeper philosophical level, the acceptance of law as an autopoietic system, or that the law is in fact alive. So this is an extension of that, as a matter of fact. So we talked about more precisely about what asymmetrical market imperfections are, and how they relate to racism, and how the structure of the free market, or the supposed free market, are not only imperfect generally, as to anybody, but they are also asymmetrically imperfect with respect to race. In other words, perfect competition. The competition is imperfect. Not everyone can enter any market that they choose. However, the barriers to entry are disproportionately and different and disproportionate with respect to Black folks. That when it comes to information, of course, it's imperfect naturally. However, the structures within the media, within public education, etc., means that the information about Black folks, the information available to Black folks, is disproportionately and differently asymmetrical. It's less, right? And again, when we get to transaction costs, when we talk about crime and environmental hazards and whatnot, justice, that the transaction costs of society fall disproportionately and differently upon Black folks. So that describes asymmetrical market imperfections and why the market is not free, right? So we already know it's not a free market, and therefore it does not produce merit, as some suggest. But that is the goal, right? The goal of any society, and that's the importance of talking about Afrolantica, because when we conceive of Afrolantica, then we know, then we're less reactionary. And we know that, or we should assume that, yes, economics is important, interpretation is important, structure is important. The insights of critical theory are just as important. However, we want a well rounded conception of what is the better system. Okay, take a break, or I'm sorry, a breath, and get to the point of this particular episode. And in this particular episode, again, instead of describing asymmetrical market imperfections, we're going to defend it legally, right? And what I mean by legally is that within the law game, within the statutory interpretation, or more specifically, what judges do when they disagree about what the law means or requires. In other words, the Supreme Court is faced with the law. Right? They're supposedly not making it up as they go along. There's something written in a constitution, or there's something written in a statute, and that is what I am interpreting or constructing. And it's interesting because just the difference between those two words means something in legal theory, right? Interpreting versus constructing, right? And it means something with respect to democracy, right? When we talk about the legitimacy of what judges do, first of all, um, do they mean what they say when they write what they are saying, right? Are they consistent? And then, secondly, consistent about what? What are they allowed and not allowed to consider that makes a judge's opinion right or wrong, or legitimate or illegitimate, right? Part of that goes back to democracy. So the fight, or the interpretation wars within American law schools, have often centered around this idea of democracy, right? Judges, think about it, have life tenure, and at least federal judges do, have life tenure although they weren't elected, right? They were appointed. And so that's theocratical, right? That's democratic. So if you have a legislative branch of government that represents democracy, if you have a presidential branch or an executive branch that represents more or less a monarchy, although it's limited, of course, and then you have a judicial branch that's unelected and has life tenure, then again, this is clearly not a pure democracy. And then to make it more problematic, what if the judges see themselves as more powerful than the legislature or the president, right? At that point, your claim to democracy is lessened. And does that matter? You could still say you are a democracy. Well, if you're running around the world telling other people that they are or are not a democracy, perhaps it does. It also matters again in a power thing. Legislatures and presidents are easier to control with money. So those with money would prefer that the power of the executive and the legislature be above those that are more theocratic, right? And again, I'm not suggesting that that's improper, it's just what it is. Not saying it's proper either. All right, so that frames the discussion, that frames the fight. What is it that judges are allowed to consider? And so the law, or at least American law, thinks in terms of text, intent, and purpose, right? So if the body of American law, how it thinks, right? We talked about law as a living system that's collectively created out of discourse, or consisting and comprised of discourse, that's self-referential, which means it has its own internal logic, that once you inject discourse, right, you don't get to tell your story to the judge. You have to filter your discourse through your lawyer and the questions, and this and that is admissible or not admissible, right? The law system eats discourse, but only in a particular way. It doesn't eat everything, right? And that's how it's distinct from its environment, and then goes through a legal process to think about things, right? And so now we're talking about its highest processes, right? Supreme Court judges, how they set the tone for how the rest of the law is supposed to think, or how the rest of the body of the law is supposed to think. And in American law, in American jurisprudence, there's basically three accepted components, factors. That is the text of the law, what it means. And when we say the text of the law, we mean more precisely what it means to the person reading it. We're going to talk about how that we can pick at that. It also thinks in terms of intent, and I should have probably may even have should have started with intent, because again, when it comes to whether or not judges are subordinate and following democracy, i.e., the legislature, this thing of legislative intent becomes very important, almost paramount. Within American jurisprudence, and perhaps within Afrolantican jurisprudence. But again, we're going to talk about what is before we go to what's next. And then there is also purpose. And purpose is a cousin of intent. Sometimes we're going to distinguish them, but sometimes they're undistinguishable. But basically, intent, when I say intent by itself, I mean intent as to form, right? The frame, the factors, the way in which something is supposed to look, or its essence, versus purpose, which goes to consequences, right? That's a very big difference in the law, the difference between text and intent as formalism. What is the form that was thought of or understood? What is the essence? What is its shape? We'll talk about a square and a chair and stuff like that later when we talk about form versus function or consequences. And consequences are basically, what are we trying to accomplish, right? And so purpose is the cousin of intent, right? Intent goes to what the legislature or the author um, had in mind. Purpose is what they were trying to accomplish, right? The consequences intended by the author, right? So when it comes to American jurisprudence and democracy, those three factors are heavily important. Why? Because they all emanate from the legislature, right? That judges justify their decision on whether it's X or Y based on the text, right? What is understood, what they wrote, right? And then it's also supported by the intent of the legislature, as supported by evidence such as legislative history or reenactments and other things, or even the regulations and rules thereunder, forming the intent of the legislature. And also, those things can go to purpose. What is it was the legislature was accomplishing, and does the interpretation that's offered by this litigant fulfill those purposes better than the one that's offered by this litigant, right? Or this appellant versus appellee, right? The judges have choices as to which interpretation they think best fits, right? That's a Dworkinish term, right? That best fits um, the case or the system or the body of law. Another problematic thing. What we're talking about, fit what? All right. So American jurisprudence thinks, the body of law thinks in terms of text, purpose, and intent. And there's a huge fight over a fourth category, right? Fourth category, according to William Eskridge, is called modern dynamics. The consequences untethered to legislative expectations, right? So he's going to call it modern dynamics. William Eskridge is going to call it modern dynamics. I'm going to call it modern dynamics too. You have heard of it in popular discourse, or at least news discourse, as judicial activism, right? So now you can get a better sense of what folks mean when they say judicial activism, or at least those who are serious about the term. Some people can just throw it around willy-nilly, but those who are serious about the term, what they really mean is that the judge considered something that was outside of the box, outside of the legislature's writing intent as to form or an intent as to purpose, that they went on their own, that they are allowed to freestyle and just decide cases based on their own personal sense of justice. Well, it's interesting because the body of American law is not clear on that. It's fuzzy on this, right? And because of that, I think it causes harm within the system, right? There's some incongruence when there is some that say, yes, we accept dynamism, and some that don't. So, and again, William Eskridge, on the one hand, and critical race theorists are typically dynamists, right? They are asking for, or at least believe they're asking for, or their writings indicate that they're asking for courts to consider group subordination and racism, even though it may not be within the intent of the legislature, right? You know, it's just the right thing to do. And that's from the, let's say, quote unquote left, whatever. On the right, right, there's Justice Posner, who also believes, who is one of the lions and chief architects of what's called law and economics. And law and economics, critical race theory see each other at odds often. I meld them, and that's kind of also what this whole project is about, because they're both important. But in American Legal Academy, they're at odds. And so, but at the same time, you can see here the link between the two. That Judge Posner, right? He's Seventh Circuit. He's not on Supreme Court. On the Seventh Circuit, he will argue that economics, right, efficiency, that Judge Posner is a philosophical pragmatist, which I also consider myself. And so he's saying he's not going to say you don't have the right avenue to justice. He's just going to say that others may also have it. It's not clear what is just. And since there is such wide disparity as to what is just, then perhaps judges should focus more on on the factor or factors that they believe all of the people in the United States can agree upon, and that would be efficiency, right? That the country wants to be wealthy, well run, and non-wasteful. Now that's taken at face value, hard to argue with that. Now there is some politics behind it, because that's modern dynamics. It's not accepted by most jurists, even though Judge Posner is heavily respected, and although law and economics is a growing discipline. But as far as this acceptance that dynamism is an appropriate means of deciding cases, I don't believe that you can say that that's part of American jurisprudence at this point. I can say that folks are trying to make that happen. Um, and the style wars seem to have died out as Professor Eskridge seemed to be winning the argument, and with Judge Posner agreeing with him from an entirely different perspective or context. But but to say that American jurisprudence, to say that the Supreme Court has adopted the notion that they can consider any consequence. And remember, when we talk about the Supreme Court, they are the leaders or the administrators of all of America's courts. So what they do is not just decide cases, they decide cases in the way they expect lower court judges to decide them, right? They want others to copy their style, their format, so that there is some regularity into the due process that you are owed, right? Meaning that you're judged by system of law, not by individual people in their own um, whims, right? And so part of that, if you're really serious about it, is that when I decide cases as the Supreme Court of America or the Supreme Court of Afrolantica, I am not just deciding who wins or loses on this case. I am setting a rule that others will have to follow, and I have to state it in such precision that those judges that are in one corner of the country versus another corner of the country 3,000 miles away will tend to come up with the same decision, because we want everyone treated the same when they are before the eyes of the law, right? The eyes of the law, right? The law is alive. So modern dynamics is, and when I talk about group subordination, that's more or less what I'm suggesting is a major distinction between Afrolantican jurisprudence and American jurisprudence, right? It's not just that we would consider it asymmetrical imperfections. It's also part of the fact that Afrolantican jurisprudence would accept dynamism, that it is not threatened, that I would argue it should feel less threatened about protecting the purity of democracy by hamstringing judges, because judges, even though you can argue that they decide cases on their personal whims, it's not the case. Can't be, for the reason I just stated. It's a system, right? If one judge got to say his piece and then that's it, then we could accuse it of such. But the fact that there are lower court judges, circuit court panels, en banc decisions, all the way up to the Supreme Court, et cetera, means, again, this is a collectivist discourse, right? And the beauty to me philosophically of collectivism and discourse, and accepting those things as little t true, is that it accepts relativism without conceding to nihilism, right? So we can't claim a truth and exclude people and say that your stuff is unworthy or whatnot, but at the same time, we can say this is the law according to X, or this is the hip hop according to Y, and that makes your thing or your suggestion or interpretation consistent or inconsistent with it. And I think that's what we're looking for specifically. All right. So again, modern dynamics, a huge difference between asymmetrical market imperfections, modern dynamics, autopoiesis. Three things that distinguish Afrolantican jurisprudence from American jurisprudence, or at least if I had my way. There's also, again, the insights of critical theory, right? The idea that group subordination, power, elitism, plutocracy is always behind the scenes. That's also a reason why um, I would justify consider judges considering modern dynamics, because we know that the text of the law, the intent of the law, the purposes of the law, as stated, can often be pretext. It can be bought by powerful forces and used for purposes that the law ought to recognize if it's harmful to the body, the national body. Look, again, the nation as a body. So those are the three different ways. Now, we're going to pull back, right? Because now I've given you, again, a more precise distinction between Afrolantican jurisprudence and American jurisprudence than we've done to date. And this is already episode 7, right? So let me pull back and have some fun. And I really feel like I need to do this so that you can understand that I am not proposing my system of Afrolantican jurisprudence. I am not presenting the American system of law as truth, right? To have productive discussions on what will be or could be. I mean, we're fortune telling, right? We're trying to forecast the future. And so I would really like to preemptively take down the temperature of our discussions and whatnot. In other words, I like to have, again, this is serious. When we're talking about race and power and economics, it's serious. But at the same time, we're not soldiering right now, right? So let's. There's nothing wrong with having enjoying the thought process and how we take it. And so I'd like to kind of preemptively take the temperature down on our disagreements and arguments, because naturally that's what this is about. You're going to disagree with what I'm saying. I'm going to disagree with your saying, but I want us to be so focused on the fact that we're all trying to help out the people that we forgive each other. And part of that is for us each to accept, again, none of us have access to the big T truth, right? So so let's talk about that. I'm not a philosopher. In my view, philosophers study philosophy. In other words, they study what other philosophers have written, what philosophy is, the different discussions they had. And to be a master philosopher is for you to understand the discourse of philosophy, right? As much consume as much of it as possible and be able to teach it, not just to think deeply, right? So I am not a philosopher. On the other hand, we want philosophy is about consistency and coherence, and so we want, again, our theory to be as clear and coherent as possible. So let me just give you the perspective that I'm coming from, philosophically, or from an essence or core. And that is, number one, that no, I do not believe that humans have access to truth. There is a truth. I do believe that. However, humans don't have access to it, right? We can observe this, that, and the third, but because we are just naturally and inevitably and imperfect, there's no way that we have access to what is absolutely the truth. What was true 5,000 years ago has adjusted 7,000, 2,000, 1,000, 50, 20 years. Things keep changing to the point where what you knew before is something different to what we know now. And so to me, that requires us to be humble, right? To always know that there's a flaw. And that's part of what we call skepticism, right? On the one hand, we're being pragmatic about the truth. I don't know what is going to be true tomorrow, right? Because imagine if there is, right, there is God. A lot of you, I'm sure most of you, believe that there is God in some form, fashion, power, spirit, entity, force, whatever the case may be. Well, if you believe that, and I would suggest that way more than majority of people do, that force is greater, is that which created us. We didn't create it. So if it decided to do something different tomorrow that we've never observed before, what are we going to say? That's wrong, right? We're going to observe it. We're going to adapt to it. So we're, in my view, instead of the absolute truth, what we are really looking for is coherence. That when we're looking for coherence, we're looking for consistency with all things that have been done or said about the thing, right? And so that, again, think about it. When you know a lot about the thing, a lot about what's been said, a lot about what's been written. You've read all newspapers accounts, you've studied books, you've watched videos or whatever. You've consumed a lot of the thing, not everything, not everything. You've not. There's no way you've consumed everything, all the discourse about this thing, but you've consumed a lot. You consumed a lot. And so when you hear statements, you are then thinking about, is this consistent? Is this coherent with all the things that I have read, all the things that I have understood about the thing? Knowing that, no, I don't have a hold on the truth of the thing. Right. And so again, that's why we privilege those who spent lots of time consuming, right, scholar about, I've written, read all these things about the thing, and therefore I can tell you what's consistent and inconsistent about the thing. And again, as someone who has never who's just come upon the subject, you don't trust their judgment, in part because you're saying your statement, you believe what you're saying is consistent with what experience, with what do you know, right? And that person could be right, but you don't trust it because it's not, they don't have a experience and a body of proof, right? Of experience, of data, to say that what I am saying is consistent with what this is, right? And so again, so we're talking more or less specifically about collectivist discourse. That to know the law, to know any particular subject, what we're trying to do is consume all the discourse that's been said about it and arrange it, corral it. And that's what leads us again to this theory of autopoiesis, right? That what the thing was today, it is a thing. It's real. It has structure. It has form. It has a distinction from its environment. It thinks. And yet, tomorrow, it could adapt to something different. Is it likely to wholly transform one day to the next? Not likely, not impossible. Nuclear bomb or some war or some tragedy or whatever. But the likelihood is much greater that the body of law will change gradually over time. And who knows, at a certain amount of time, it may not look like it used to. But at the same time, we know that it has structure, but it also looks outside itself. That leads us to, again, the idea that judges who decide cases would do so in an everyday pragmatic sense. That there is the difference between a philosophical pragmatism and an everyday pragmatism. Everyday pragmatism deals with cost benefit, right? Philosophical pragmatism deals with the idea that that we're going to be humble with the truth, right? That we won't know exactly what the precise truth is until we meet our creator and ask him, right? But everyday pragmatism is slightly different. It stems from the idea of cost and benefit, that we will address some things, that there is no good and bad to everything, that we're going to take the good of textualism, while recognizing its cost. We'll take the good of intentionalism while recognizing its cost. We'll take the good of purposivism without ignoring its cost, and also dynamism. As a critical race theory, I have to break ranks and argue that dynamism has its selling points, but it also has its costs as well. Um, so that is a description of law and how the law thinks, how we conceive of it structurally before we even get to what are the laws, right? So I want to prove this to you. I want some of you are saying whatever, there is a truth. You have access to it. Judges shouldn't be scared, or we can't be humble about our redemption. And I can't disagree with all of that, but I am going to say that while I think you should be confident, I still think that we should be skeptical and pragmatic about the truth. Let me start with this. Does 1 plus 1 equal 2? Always and forever, right? Because that's what we're talking about, or at least what I'm talking about when we're talking about truth. Does 1 plus 1 equal 2 last week, last 1,000 years, today, tomorrow, and 1,000 years from now? And I've purposely picked 1 plus 2. You can imagine, because Obviously, if we're talking about true and humans not having access to it, you say, hey, 1 + 1 = 1 works. Well, yeah, it works. That's consequential. Whether it's true in form, I don't know. And does it always work? So let's play with it. 1 + 1 = 2. Well, what if you are in a binary system like a computer, right? Computers only have zeros and ones. So if you have 1 + 1 in a computer, then you have basically 10, right? 1 and 1 equals like 1 0, right? So 1 + 1 does not equal 2 in that particular circumstance. Okay, we're not in that circumstance. Let's use a different circumstance. Okay, I had a buddy had a fish tank, um, and he bought a snakehead and a goldfish. So that's 1 and 1, 2 fish, right? No, that's 1 fish, right? 1 goldfish and 1 snakehead equals 1 snakehead, right? The goldfish is not going to make it, right? So, okay, so we had 1 + 1 equaling 10. Now we got 1 + 1 equaling 1, right? What about 2 rabbits? You got a rabbit, you got another rabbit, you got 2 rabbits. Well, anybody got rabbits? No, you got 3, 4, 5, 6, 7, 8, 9 rabbits, right? They're going to reproduce. And you're saying, Professor Smith, you're not playing fair. It's not the same rabbit, right? It's a male rabbit and a female rabbit. I got to get the same rabbit. And if you get the same rabbit, you got 1 rabbit, you got 2 rabbits. 1 other rabbit, you got 2 rabbits. All right. Is there 2 of the same of anything? Because if you grew up the way I grew up, you were taught that that even a snowflake, that there are no 2 of the same snowflakes. As many flakes of snow fall out of the sky, that there are no 2 that are exactly alike. Which means I got 1 snowflake, or and the other one is what? 0.1 of a snowflake. Oh, I'm sorry. Well, that was the real one. The first one I had was 0.9999999999999999 of a snowflake. Can you even get to 1? Let's, matter of fact, before we even get there, can you even get to 1? Has anyone ever gotten to 1 perfectly? 1.0 to eternity? Or have you always been at some level close to 1? 0.9999999999999999999, right? Can you ever even get there, right? If you're shooting, it's one thing if you're shooting something across the room, but if you're shooting something to Mars or out of space, there's just a different level of precision. Engineers understand this, that they're not looking for perfection. They're looking for a mathematical computation or precision up into the necessary degree to be functional, right? Um, Unless you've seen a 1 just in nature, right? Maybe I'm wrong that you can get to 1. You're not always at 0.999. That in fact you saw a 1 running across the street. It was almost hit by a car. You said, "Wait, 1, stop at that light. Can't jaywalk." I've never seen a 1 in nature. I've seen men create 1. I've written 1 on the paper, and we've agreed that there are 2, right? 1 + 1 = 2. And to the extent it works and it's functional, great. But the idea that it is universal, that it is timeless, it is immutable, that it is not contextual, I think we just picked at that. And if I can pick at 1 + 1, then there is no argument. There's really no argument that can be made, and therefore there is no judicial decision or interpretation or whatnot that also has this claim to truth, right? That it all has a claim to being consistent or coherent with this principle or that principle, but truth, not so much. Matter of fact, let's even bring this closer to the law. We just talked about 1 + 1 = 2. What about a chair? What is a chair? Because that's the type of thing we're getting closer to when we talk about the law and you're a judge. What is murder? right? In order for it to be murder and this person to be a murderer, we have to have a definition of murder that excludes people or excludes this, that, and the third. So, for example, let's take a square, right? There's a square has a form that is supposed to have four equal sides and four 90-degree angles. And if you don't have that, it's not a square. That is the conception of form that we all understood and hated, well, for most of us, in geometry class. That it's not a square just because you say it's a square only after you measure each side and determine that it is consistent with the theory and the rules that you have. Law pretends to be mathematics, right? Law pretends to think mathematically, right? That this is a thing, this is its form, and that what you have done either fits within it and therefore you go to jail, or what you did not fit within it and therefore you don't have to go to jail. But again, the realist argues a little different. We don't always know precisely what the form is. We just played with this thing. Has anyone ever had a square? There's an argument that there's never been a square in the history of the world. Why? Because again, are we at 90-degree angle precisely? You're always going to be able to find something or some meter that's going to find it off at some point. 89.9999999999999999997, and it's off, right? And it's off. So the question becomes, was it square-y enough to accomplish the goal that we set out for it? Again, let's do this with a chair. Let's do it with a chair. A chair has legs, and then you sit four legs and a seat. Then I find you a tripod or something like that, or a stool with three legs. Then you say, okay, well, it still has to have legs and a seat. And then I show you a beanbag chair, right? No back, no seat, whatever, but it's people calling it a chair. And then you say, well, I got you, Professor Smith. A chair is something you sit on. How am I going to defeat that? Until I point to a picture on the wall with a chair in it. And I say, okay, that's not a chair because you can't sit on it because it's a representation of a chair on a wall. So again, we're talking about this idea of form. What is the precise form of a chair? What describes it? What is its essence? What are the rules? And we find that we can always pick at that. Then we talk about, well, what is the purpose of the chair? And we are always going to be able to poke at that. So again, this 1 + 1 not equaling 2, this idea of never having a square, this idea of we don't know what a chair is, right, is all to commit to some type of humility as to what is the truth. That when we decide that I am right or wrong about a case, or if I am advancing a particular theory, yeah, I think this is the best I can come up with, and I think it is that way because it is consistent and coherent with those things that I know or I believe are important with the past. And people that disagree with me, all they're saying is it is not consistent with the things that they believe or they have written or heard or read or in the past. Remember, Malcolm X said, never be mad at someone who doesn't know what you have come to know, because there was a time when you didn't know it either. Let's bring it to the law. There is a famous trope or hypothetical called no vehicles in the park. No vehicles in the park. For those of any law professors out there or even law students that have taken jurisprudence, you just rolled your eyes. Vehicles in the park. Yeah, no vehicles in the park. We're going to go through again how the law thinks. We just did this exercise in pragmatism to get to this idea of how the law thinks. No vehicles in the park, and how using different techniques could end up with different results. And that's all we want to prove here, right? That's all we want you as the listener or the watcher to accept as far as jurisprudence is concerned, is that there is reasonable ways to come up with different interpretations, and that is the essence of our fight. Now, yes, in Supreme Court, which technique I use and which result I come up with, yeah, it can be very highly political, but there is an underlying logic or structure or understanding about this. And again, in autopoietic system, we're talking about how the law thinks. So no vehicles in the park, right? You got this park, and there's a sign that says no vehicles. So the question becomes, what is a vehicle? And so when a cop comes, a peace officer, an administrator, or even a judge that's reviewing the case, let's make it that way. Let's say we just have an over-exuberant police officer. Where would I even imagine that at, right? So we have an over-exuberant police officer that's just giving tickets to every single thing that even remotely looks like a vehicle in the park. I mean, he's trying to make his quota. He's trying to get paid. The city needs money. I got to get my bonus and all that. So no matter what it is, if it got wheels on it, if it even looks, smells, tastes, sounds like a vehicle, he's writing tickets. And then everybody that gets a ticket goes before this judge, including a child with a little matchbox car, a little metal car that rolls around the ground, right? You could even make them plastic, something out of McDonald's. An officer zealous said, that's a vehicle, clearly, right? Textualism. What does a vehicle mean to the average person? What does it mean? Well, we'll get there in a second. A matchbox car, a wheelchair. So he gave a ticket to somebody in a wheelchair because he said you were in a vehicle. Also, he gave a couple of them. He gave to a wheelchair, a manually pushed wheelchair, and a automatic wheelchair that goes 30 miles an hour. He also gave a ticket to someone on a Segway, right? The thing, instead of walk, you're on the Segway. He said that's a vehicle. Gave a ticket to it. My man, Officer Zealous, gave a ticket to a drone, somebody flying a drone, said that's a vehicle. And also gave a ticket to a sculptor. He's walking around the park. He sees a sculptor creating a World War II or a Desert Storm memorial with a tank in it. Says, my man, that's a vehicle, and he gives him a ticket. Incredulously, the artist took it. All of them show up before this judge and say, Judge, I did not have a vehicle in the park. Right? I was in the park. I got a ticket. Cop says it's a vehicle. I say it's not. Right? How is the judge, again, to justify? Now, again, we could just say yay or nay. Right? But again, we want to avoid the law of man, the law of someone's personal whim, and we want them to justify that decision. And we want them to justify the decision. I argue, not so much to say that it is right in the truth, or that you'd like it to be that way, but again, to show that it is consistent with the way in which we have judged other things everywhere else and whatnot, so that what the product of this decision is the product of the system and not the product of the fact that you just don't like me or whatnot. And hopefully that system is designed towards to produce merit and justice and what have you. When it doesn't, then yeah, the whole thing falls apart. So again, no vehicles in the park. Let's go through the way the law thinks and look at and think about these different so-called vehicles and see which one gets a ticket. So text. Textualism, and this is the theory espoused by the departed Justice Scalia. This is the theory espoused by Justice Thomas, right? The only black member of the Supreme Court. I do ascribe him to blackness, although I'm sure some of you disagree. He is, in fact, the most strident and best textualist on the court. So a lot of critical race theorists, including myself, criticize textualism, and so we don't. So he doesn't get a lot of props for that. At the same time, I think we ought to recognize, no, he was never Scalia's lapdog or following in Scalia's footsteps. He was actually, even though Scalia wrote the book Matter of Interpretation, when it comes to actually deciding cases, Justice Thomas is a much better textualist than Justice Scalia was. All you have to do is go to U.S. versus Kraft in 2002, a tax case, and others to see Justice Scalia opining on consequences untethered to any legislative expectation, right? Dynamism. Well, he does so in dissent, but he'll also do so slip up to sometimes do it in decisions as well, where Justice Thomas does not slip, right? So this idea of textualism, deciding cases strictly on what the people understood the law to mean, right? Not what the author intended, but what the reader understood. It could be two different things, right? So when we talk about where would we find that then? What the people understood, right? Textualists are fond of using dictionaries, right? Dictionaries. Now, the problem sounds reasonable, but then the problem becomes, again, the definitions in the dictionaries change. There's more than one definition in the dictionary. And then number three, um, the dictionary doesn't even know the meaning of friends. Houdini fans, where are you at? All right. The dictionary does not define lots of different stuff. On top of the fact that Congress and legislatures often make up words that were never in a dictionary to begin with, or combinations of words. And again, the courts have to decide what it means when individuals in society can't agree. As a matter of fact, again, I've written a text called, well, we'll talk about it later. Does it matter what slaves thought direct tax meant in the U.S. Constitution? It's in the Constitution, direct tax. Founders wrote it, never knew what it meant. People didn't know what it meant. All right. All right. So that is textualism, to focus on the text, the obvious or so-called plain meaning of vehicles. And if we're talking about the plain meaning of vehicles, then just about, I don't know, all of these things maybe get in. So that's the problem with plainness. Is a vehicle, is a wheelchair a vehicle, plainly? Um, 5 miles an hour, 10 miles an hour, 30 miles an hour. At what type of time is it, at what point is it plainly a vehicle? Same thing with a Segway. I don't, to me, I'm sorry, it's hard for me to say plainly a Segway is a vehicle. Maybe a vehicle is something that carries other people, right? Not just something with a motor and moves. So that brings us to text. That brings us to intent. What was it that what was the legislature thinking when they said no vehicles in the park? Were they thinking of cars? Were they thinking of trucks? Were they thinking of bicycles, dirt bikes, motorcycles? Is there some way we can look back at their discussion, what we call legislative history? Can we look back at their discussions, their meetings, their speeches, and try to determine the scope of what they intended to outlaw in the park? Because I think if we did, let's say the little kid's Matchbox car, it's probably highly unlikely that you could, if the legislators spoke on the matter, that they would have included and spoke about different vehicles that look or resemble anything like a Matchbox car. And probably, since all of the ones they probably talk about are able to move, it might be harsh or outside of the intent, obvious intent of the legislature to give a ticket to the sculptor whose sculpture includes a tank. That tank is a vehicle under plain meaning. I don't think there's any way around it, right? So under plain meaning, it gets a ticket. And we'll talk about absurd consequences later, which I don't know, just opens up the door, the exception that could, in fact, swallow the rule. Well, so text says, what did the people understand vehicle to mean? Intent says, what did the author mean when he said vehicle or she said vehicle? Purpose, as we mentioned, is a slight move over. Instead of the form of the vehicle, what it looks like, smells like, sounds like, the next question is, what were the consequences that the legislature either sought to avoid or bring about, right? That's purpose, right? You've heard intents and purposes, right? They're cousins, right? One is intent is to form, purposes to consequences. So what if the legislature was trying to prevent noise pollution? right? If the legislature was intent, if everything that was said in the legislative history and the debates and all that, and the complaints and those things that the citizens wrote in to inspire the law was all about loud noises, right? The residents around the park just were tired of the dirt bikes and all that other stuff, and so vehicles being loud, right? This noise pollution thing. Well, again, the Matchbox car, the tank seem to not be vehicles, even if they may be considered such in a plain meaning sense, and even if they were or were not included in the original frame or intent. Even a Segway, right? Because a Segway doesn't, I don't believe Segways cause noise. And so, if noise pollution was the reason to outlaw vehicles, Segways may seem to get a pass. That because it's equivocal one way or the other, like, no, for this purpose, we don't see Segway as a vehicle. Um, what if the purpose was different, though? What if the purpose was because there were a lot of accidents and injuries, right? And people were getting hurt in the park. People couldn't jog because of just so much activity, and they just wanted to pare down the amount of people that use the park. Well, in that case, I think the Segway gets kicked out of the park at that time, at that point. If that is the known, stated purpose to stop accidents and injuries, right? Even the Matchbox car, I'm not sure, right? The little kid, maybe got to take that on the side, but clearly, but probably not the drone, probably not the again the World War II tank or the Desert Storm tank. So that is how American law tends to think: text, intent, and purpose. And we see through no vehicles in the park that there could be a difference. Um, Modern dynamics, right? That's the controversial. That's what's not accepted outwardly or expressly within American law, which I would ask to be accepted expressly in the Afrolantican jurisprudence. And that is consequences untethered to any legislative expectations, right? So again, judges are more or less freestyling. Now, the reason I think I'm overselling it or I'm over discrediting it by calling freestyling is because in Afrolantica, we're being pragmatic and we believe the text, the intent, the purpose, and modern dynamics are all important. That the easy cases are when the text, intent, purpose, and modern dynamics all line up together, where we say, look, this is just wrong, right? It's against the text, it was against the intent, it was against the purpose, it's the wrong. Nobody in society thinks this is a good idea. It's not going to bring about any good consequence. That's an easy case. But again, there are cases where they point in different directions. And what I believe should happen is courts need to be express about what it is, why they believe it is consistent with the text, why or inconsistent with the text, why consistent or inconsistent with purpose and modern dynamics, etc. But again, modern dynamics is something outside of the legislature's grasp or outside of their realm or cipher that judges in Afrolantica jurisprudence, I believe, ought to consider. So let's take again no vehicles in the park. And let's say assume this park was not being used by anyone and it had overgrown vegetation, bottles, broken glass everywhere, that it was being used for illegal activities. It was just a nuisance. And let's say some dirt bikers, right, come along and they need a place to ride, and they clean the park up, top to bottom. Nobody had used this park in 20, 30 years. They totally clear it out and put dunes in it and start taking off and having a great time. Next thing you know, somebody says, somebody moves into the neighborhood, doesn't like the dirt bikes because of the sound, or they can't walk their dog in this park that they said, oh my God, I see this park here. I just moved in the neighborhood. They don't know the history of it and say, oh, call the cops, get these bikers out of there. Well, yes, dirt bikes clearly within the text. Most people would consider dirt bike a vehicle. That also within the intent. It's hard to find an intent of a legislature that would say vehicles that would exclude a dirt bike when we're talking about a park. So when we're talking about noise pollution, accidents, doesn't really, I can't. you're going to exclude vehicles from the park, dirt bikes seem to be a heavy qualification, right, as to text, intent, and form. But yet, in this instance, I set it up the facts so that it would just seem to be entirely unjust to kick these dirt bikers out of there because the modern dynamics of merit that they applied their labor against a quote unquote wilderness and something that was being unused, that they made something useful out of nothing, suggests that they should not be excluded or kicked out of it after expending resources and time and not harming anyone or whatever the case may be. So that's the way modern dynamics also operates. It's high. Well, we'll talk about it in a second. But one of the some people say Brown versus Board of Education um, inspired this whole debate. But we'll try to address that a little bit later. I guess we could also inject critical race theory, the argument that powerful forces, unstated forces, just operate behind the law when it comes to racism, sexism, plutocracy, elitism. That no matter what is stated, the legislature may state that this is a particular purpose or intent, but that if oil or some natural resource that was very commercially useful to a large corporation would also bring large tax dollars and payoffs to local officials, that somehow whatever is going to get kicked out of the park in order to serve the interests of serve the powerful interests that want that park. Or on the other hand, if on the other hand, so a powerful interest wants to use the park and yes, vehicles on it, that somehow the interpretation will come about that allows for it. So that's the essence of critical. That's the insight of critical race theory. And also, again, why I suggest dynamism is important, because if that is at play behind how is a judge to address that? If a judge knows that to be going on and knows that text, intent, and purpose are being used as pretext, then how, other than saying it's inconsistent with these other values that are unstated by a legislature, do we ignore or address the improper influence, as we'll call it? Okay, so we talked about 1+1. We talked about what a chair is. We talked about no vehicles in the park. And so now I hope you have a stronger understanding of legal interpretation as it relates to jurisprudence, so that now I can justify why judges in Afrolantica, and as a matter of fact, I guess my point is more so that judges even in the United States basically have no excuse not to consider Afrolantican Jurisprudence, I'm sorry, asymmetrical market imperfections as a proxy or as a definition for racism or economic subordination. And where it occurs, if a law or an interpretation exacerbates these asymmetrical market imperfections, then they should be set aside. So I'm going to go through two different approaches. So because some theorists say that you have to look at different texts differently. So some people look at a constitution differently than a regular statute. But again, I don't think it's going to matter here, because I think that we have authorization to for judges to consider asymmetrical market imperfections. So let me start with, again, let's start with the Constitution. Let's start with William Eskridge or others, or Bruce Ackerman, let's say, who believe, again, in a living Constitution, that it is okay to consider consequences outside of the framers' intent or what have you. And again, I think a good bit of these debates, this war over statutory and constitutional interpretation, stems from Brown versus Board of Education, right? The idea that Plessy versus Ferguson dealt with this idea of separate but equal, right? Equal protection of the law. That it stayed very consistent with the text, even if you don't like it, right? And for Brown versus Board of Education to depart or inject its own text into the Constitution, right? That's to consider that which a 19th century Congress would not insist upon for it to go on its own to protect Black people or racial minorities to them is, oh, well, we're not arguing about the justness of it, right? They're arguing about the appropriateness, the legitimacy of a judge doing that, that is more appropriate for the legislature, right? So, again, as Black folks, we think that that's just hyper technical. But again, the reason why we're using Afrolantica as a hypothetical is because if we were Supreme Court judges of Afrolantica and the issue was something different, yes, we would in fact be within our rights and actually duties as law professors, as jurists, as philosophers, to make sure that our body and law system is has a high level of integrity, right? So, Constitution. Let's start with again the idea. If it's dynamic, then you consider asymmetrical market imperfections as a proxy racism. Very simple. What if you are a purposivist, such as Justice Breyer or John Hart Ely? They have used their intellectual talents to argue that Brown versus Board of Education and others fit within the purpose of the Constitution. It's interesting the way they get there, but let's start there. They say that it fits well within American jurisprudence because it's not dynamic, that it's purposivist, that they read within the Constitution a purpose for a fuller and more robust participatory democracy. That regardless of what the founders, who they were, regardless what they say, regardless of the text that they wrote, they aspired for the country to get to a higher plane. And that through the text, and here's what's interesting about their purpose. When you talk about purpose, you're talking about intent. So the question becomes, how do you ascribe a certain intent to an individual? Did you look through the so-called Federalist Papers, or did you look at other things, again, speeches, discussions, to say that this is what they said? Oh, don't listen to what we're saying now. Don't read what we're saying now. All of this is a setup for a better future. We like to think of America's founding fathers in that way, but in reality, those that wrote the U.S. Constitution were much more pragmatic and worried about events of the day, much more than they were this um, to create such an angelic document. Yes, they were guided by some philosophical folks, some very deep thinkers, but it's still, the U.S. Constitution is still absolutely was a practical document. It was a tax document, as a matter of fact. People say why. What was the? It was a weak central government. Why we got rid of the Articles of Confederation? Yeah, it was weak because we couldn't have the power to tax, and so we needed to be able to tax stuff in order to buy some guns and fight the British and Native Americans. So it had a real practical reason for coming about, and those who wanted it and signed it knew that it was useful more than they knew it was grand. Um, so the interesting thing is, so going back to John Hart Ely and Justice Breyer, so then where do they get this idea that it was a purpose? And they find it out of the text, right? That's interesting, right? Text-based purposivism. That they say if you look at the text, the whole body of the Constitution, that it emanates, right? That this purpose protrudes from it. Now you can't mistake it, right? They use terms like liberty and things that they clearly couldn't have meant statically, right? They knew when it came to liberty, they were inconsistent with their principles. It was clear, right? So for them to write such highfalutin stuff, knowing for a fact that they weren't living their creed, and then the high sounding terms of the document leads Justice Breyer to say, and again, is the other realist judges to say that this is that we need to take this to a higher plane. Um, Textualist judges, I don't know if they would say this, but there's the argument that if the people want to go to hell, it's my job to drive them there. Where purposivists and realists argue that judges again are supposed to take the people to a higher plane. They're supposed to be smarter, and so they're authorized to consider these things. Well, so justifying asymmetrical market imperfections amongst the realists of the Supreme Court doesn't seem like it's all that hard, other than whether they are willing. But it doesn't seem all that hard. So the question becomes text and intent. Well, as I said, I think intent is the hardest, right? Whether it was in the minds of the framers. And when we talk about the framers, I guess we can talk about 18th century and we could talk about the 19th century with the 13th, 14th, and 15th Amendment. But either way, again, you're talking about legislatures that were not friendly to black folks, right? There may be one or two, right, especially in the 18th century. Some of the senators and representatives from Pennsylvania had some very prophetic and salutatory words that they can be commended for hundreds of years later, where others made speeches like Patrick Henry and others made speeches that they ought to be embarrassed about even centuries later. Um, so, originalist intent doesn't look very favorably upon asymmetrical market imperfections, right? But the interesting thing is, Justice Thomas and Justice Scalia say that well, Justice Scalia more than Justice Thomas, but Justice Scalia argues that that originalist textualism does not consider the framers' intent, that it considers what the people of the United States understood the words to mean. It's the people who had to ratify the Constitution. So no matter what was in the founders' minds, the people didn't have access to that. The people had access to the words in the Constitution, and they either voted for it or they did not vote for it. And so his argument and the strength of his argument is on democracy, number one, that it's up to the people and the people's understanding. Now, embedding the people in the 18th century, right? That's what I question. Who are the people in the 18th century? So, do we continue to restrict it to white males at the time, propertied white males at the time, excluding indentured whites at that time, excluding white women at that time? Excluding Native Americans, excluding black people at that time. There's a huge question as to whether black folks were citizens, whether we were intended to be citizens in the United States. And again, if you use just a word, which is really interesting to me when it comes to Clarence Thomas on this issue, is the word people. Again, if you're talking textualism, if you're talking dictionaries rather than a particular form that the founders had in mind, then the word people has a plain meaning that includes black folks. Um, Now, so again, or do we just exclude 200, 300 years later, do the same exclusionary tactics that we did in 18th century? Oh, no, only what it means to these people, right? It's 2017. We don't have to exclude these people at this point. We don't have to continue the wrongs in our interpretation just because. Um, so the if the plain meaning, if the text, the if the text and the understanding of the people is paramount when it comes to constitutional interpretation, guess what? That actually supports, or at least if you're believing Jeffrey Parsons Miller of New York University of NYU Law, he wrote a paper that supports the argument. He didn't know it, but he wrote a paper that did. It supported the argument that asymmetrical market imperfections could be constitutionally mandated through the Commerce Clause. So the Commerce Clause in the Constitution gives the Congress the authority to regulate, to do what's necessary and proper when regulating interstate commerce. The interesting thing here, or the interesting words, are necessary and proper. Um, they are thought to be in conjunction. They're usually talked about in conjunction, and Supreme Court has basically interpreted it down to nothing. That they do not believe it's within the Supreme Court's authority as co-equal branches of government, which is really interesting because we just talked about legislative supremacy. But whatever, this idea that judges should not second guess the legislature, that the legislature has just as important, or if not more, authority within a democratic constitutional scheme. So if judges were to just tell Congress when things were unnecessary, then basically giving the Supreme Court veto power over every law, to the court's mind would be too undemocratic. And therefore, there are hardly, I don't believe, any laws that have been set aside constitutionally for the court to say that they were improper or unnecessary. Now, the court has said that this wasn't that perhaps what you were doing had no relation to interstate commerce. But to the extent it does relate to interstate commerce, the courts don't say that this is unnecessary or inappropriate. Well, Jeffrey Parsons Miller challenges this. He argues that necessary and proper do not have a combined meaning. That these terms were used in corporate charters in the 18th century at the time of the U.S. Constitution, and that they were used independently, which means that necessary has a particular word that means more or less that officers and get to operate on behalf of the shareholders, much like the Supreme Court imagines Congress, and that they shouldn't be questioned. Under most circumstances, that they have the authority to do what they believe is necessary. That's a lot of discretion. On the other hand, here's where it gets fun. He argues that proper was used independently. And when you look at its independent meaning, it means that laws and regulations, or at least the actions of the officers and the rules of the corporation, cannot disadvantage one group of shareholders against others. Wow, okay, if citizens are likened to shareholders, then that would mean that necessary and proper would mean that an inappropriate law would disadvantage one group of citizens versus another. So to the extent we still have the necessary and proper clause, again, the plain meaning of proper or inappropriate would mean that we should set aside constitutionally laws, rules, and regulations that cause asymmetrical market imperfections, because those are inappropriate, right? They cause divisions and distinctions and disproportionalities between classes of citizens / shareholders. Okay, so let's move away from the Constitution and talk about regular statutory interpretation. And I find that, again, we don't even need to go to the Constitution to talk about group subordination, that within all form, text, intent, purpose, and of course modern dynamics, judges are authorized to determine whether or not judges in America are authorized to determine whether or not a particular law exacerbates or maintains or creates group subordination through asymmetrical market imperfections. So again, dynamism, consequences untethered to legislative expectations. Sure, judges can consider asymmetrical market imperfections. That's easy. And we're going to go back to that because what if I want to consider it, but I don't want to call it dynamism? Well, there's a solution for that. There is Aaron Barak. Aaron Barak is on the Supreme Court of Israel, and he wrote a book called Purpose of Interpretation. And the interesting thing about this is, so if purpose are consequences tethered to legislative expectations, then the next question becomes, where is the proof or the evidence that the legislature did in fact seek these consequences? And similarly, but from a different tactic than Justice Breyer, Justice Barak just defends basically the concept of objective purposes. Objective purposes. In other words, objective purposes are purposes that any reasonable legislature would expect judges to consider. So that brings in, again, Judge Posner's law and economics, but I argue that it would bring in critical race theory, asymmetrical market imperfections, because what reasonable legislature would want to laws to exacerbate racial tensions and the racial wealth gap and discord within the country or what have you? So once we accept objective purposes, it's pretty hard to close the door to dynamism, right? Especially if a judge is to consider a dynamic consequences, then that judge obviously thinks it's important, and that judge if that judge thinks it's important, it would seem odd if that judge didn't expect a legislature, a reasonable legislature, to also believe that that consequence is important in the whole grand scheme of things. So objective purposes from a Supreme Court justice in the Western styled court system has written in support of that. And again, um, we can take, let's look to intent, right? If we can go beyond purpose, let's look at intent. And this one is a little harder, but I think critical race theorists ignore to our detriment the case of Bob Jones University versus the IRS, or versus commissioner. So Bob Jones University, and then Bob Jones, why do I think it's slept on? Why do I think it's underrated? In Bob Jones University, the Supreme Court, this is 1983, the Supreme Court says that that they will not grant a charitable deduction to a private school that discriminates on the basis of race, because Congress does not intend to support racial discrimination and subordination. Whoa. Where is this? Why is this not written? Why is this case not cited in just about every single critical race theory article when we're talking about a change in the law or interpretation, right? Especially if we're talking about statutory things. That Congress, that the court believes once and for all, supposedly, we'll talk about Chevron doctrine perhaps later, that the Congress does not believe, Congress does not intend for its statutes to exacerbate or create racial discrimination. An interesting thing is that you see how hard it is to distinguish form versus intent. Does the law prevent a particular form as racial discrimination as a particular form, or does it prevent a consequence of racial subordination? Right. So again, when we really pick at all these things, 1 + 1 doesn't equal 2. It's 1.9999. Right. So we can always find the fuzziness in all this, but it gives us a very good system to use. So dynamism, purposivism, and even kind of intent, we've been able to squeeze, or I'm not even saying squeeze, that asymmetrical market imperfections is welcome within those factors or techniques or deliberative techniques. And so what's left is textualism. And so we saw that in constitutional theory. We get asymmetrical market imperfections through the term proper in the necessary and proper clause. When it comes to statutory interpretation, it's even easier. Again, when it comes to text, textualism yields to what is called absurd consequences. So go back into no vehicles in the park. Our officer Zealous gives the little child with the Matchbox car a ticket. He gives Granny with the wheelchair a ticket, and he also gives the sculptor who created a memorial with a Desert Storm tank, gave them a ticket, because those things in his mind were obviously vehicles. And let's stick with the tank, because I think that's one of the most clearly within the plain meaning. And after which we find that a judge could say that is just patently absurd. Well, again, just like reasonable, absurd, adjectives, right? Adjectives are an interpreter's playground, right? So for all you law students out there and lawyers or whatever, when we talk about truth, when we said one and a square, we're talking about nouns, we're talking about things, and the form of them becomes somewhat coherent and consistent between peoples. But when we're talking about adjectives such as absurd, reasonable, very, right, it loses its form. It loses its, so it becomes a lot easier to play with. And so absurd consequences, really bad consequences, untoward consequences, uncomfortable consequences, absurd consequences, right? To the extent a statute causes asymmetrical market imperfections relating to race, gender, etc., then to me as a judge, that would be absurd, that would be improper, it's, all of that. So asymmetrical market imperfection, and let me back up, and let me even say, because of the requirement to set aside law for absurd consequences, suggests that it's always appropriate for me as a lawyer to present race and discrimination as a consequence, and it is the duty of the judge to determine whether those consequences are or are not absurd, right? So were to, even if a textualist were to reject asymmetrical market infections, even if it was to reject racial discrimination in the proposition, they would still have to, ought to the extent it has been proposed, argue why they don't believe such a thing is absurd, right? Because again, it is a consequence in textual. It is a consequence. Textualism does require the consideration of consequences to determine whether they're absurd in the end, in basically in every case, or at least when it's asserted. So those are the four. So talked about constitutional theory. We talked about how the law thinks in terms of text, intent, purpose, and modern dynamics. And in the end, we argue, or I argue, that asymmetrical market imperfections as a legal proxy for racism is appropriate in every single one of those contexts. And because those contexts, on the one hand, have some concretism, they exist, they have some structure and bone. At the same time, just like 1+1 or a chair or no vehicles, they fray. And therefore, we should accept that they all have worth, that they all bring something to benefit the law, and that we should consider all of them. However, none of them absolutely chauvinistically, and that the idea that asymmetrical market imperfections, that group subordination, that racism should be a proper concern of judges in America, clearly under an Afrolantican jurisprudence, under an autopoietic conception of the law, where asymmetrical market imperfections is injected as a mechanism or structure or organ to allow the body of law to see outside of itself and process the information that it's getting in terms of race. There is no, in my view, interpretive excuse in the United States, and there would be none in Afrolantica. So thank you for joining us for episode 7. We look forward to talking to you about upcoming events in episode 8. Thank you very much. Hotep.